All right, I see it's 10:30 on the clock on the wall. This is the St. Croix County Government Center in Hudson, Wisconsin. We're in room 1284. It's December 3rd, Friday, December 3rd. We are meeting pursuant to notice on second day of dealing with a matter called St. Croix Valley Solar LLC, request for a conditional use permit, towns of Warren and Richmond. Therefore, I'm calling to order this continuation of our meeting of the Zoning Board of Adjustment, continuation from yesterday. And I will introduce myself and then ask the board members to introduce themselves and the staff members to identify themselves. My name is Buck Malick. I'm the chair of the Zoning Board of Adjustment currently and resident of the town of Hudson in St. Croix County. I'm a citizen member, not a county board member.
Tom Spaniel, citizen member, town of St. Joseph.
Joe Miller, citizen member, town of Hammond.
Good morning, Steve Shalla, citizen member to Pleasant Valley Township.
Scott Cox, St. Croix County Corporation Counsel.
Ellen Denzer, St. Croix County Community Development Director.
Mike Wozniak, St. Croix County Land Use Administrator.
And Julie Peterson will be recording and probably helping to facilitate some of the audio tech video stuff. We left off with sort of agreement in concept of some changes to the proposal from the zoning staff. And the thought was that overnight the applicant and the zoning staff would work out some modifications to the initial proposal with the hope that those modifications would be suitable for adoption by the board as its decision document. So I think I should, we've closed the hearing. That was done yesterday, so we won't be taking new evidence, new testimony, new documents, any of that kind of stuff. We'll be working with the record that we have. Any communication between the applicant, Mr. Seck, and your assistants would be to the zoning staff rather than to the board at this stage. And you, sir, member of the public, we will not have the opportunity for you to give testimony. So no need. I don't know if the oath is over there on the paper, but there's on the side table, but there's no need to sign it. You wouldn't be testifying anyway. We'll just work with what we've got. And principally, I expect it'll be dialogue between the board members and the staff, headed by Ms. Denzer. So I think at this time, it's a call on you, Ellen, and ask you to present what you've got.
I can move to the podium if that's needed. Julie, are you?
I'm just trying to get this computer to work, so then you can see things online. Right now, it's not cooperating.
Okay. So we have handed out to you a revised, we usually prepare for you a proposed decision document. And so instead of following along in the staff report like we normally do, we'll ask you to follow along in this document. The items that were in the staff report are in here as always, and we have revised and edited them. And so I did not have a track changes version because it was tracked, highlighted, and reviewed a little bit. So what I will just do is go through it. A couple of the things are fairly easy. On page 1 of the findings of fact and conclusions of law, number 9, what was changed was the specific begin of construction dates. We worked together to state what was added at the hearing yesterday, that the construction, they'd asked to move things back a little bit as they're anticipating a later start of construction than originally planned. So it now says fall of 2023, with an in-service date as early as December 31, 2024. And also, an in-service, it could be extended up to 1 year with an in-service date of December 31st, 2025.
She's got it up now.
Oh, you do, good. Probably be better if I went up to the podium and then, if that's all right? Okay. Take this, I don't have anything else. If we need edits, I will try to do them on here. If I can't for some reason, I'll come back to it.
You should have both of the documents here in the Word.
Okay, and that one's the right one. Thank you. Okay. All right, so that was the first change in number 9. I'm going to go down a little bit. Number 10, change the wording very slightly to say there will be up to 2 full-time equivalent, or full-time equivalent FTE employees. Before it just said there would be 2 employees. Gives a little more flexibility to the applicant. Page.
There could be none.
Yes, that's where it says up to. And that is addressed slightly later on. But they are expecting to have on-site, and they've said they will. Number 13 on the next page, that was rewritten and added, basically completely added. The applicant shall be required to enter into a developer's agreement with St. Croix County substantially in the form attached as Exhibit A. It does say substantially in that form because we had a draft, but the first time that the applicant saw it was yesterday, and we met early this morning and went over a variety of things, and we've got it really close. We all agree it's close. You have a copy of what's close, but Scott's staff is going to work on putting it into the proper form, adding the form for it to be recorded at Register of Deeds. We really quickly created 2 attachments to that document, and which I'll go over also before we're done here. And so it really will need a go-over once more, just to make sure everything is done. We did it very fast.
But the substance will not change.
The substance will not. It'll be about form. We got all done, and we were making copies. This one doesn't have it. I found a small typo, a spacing. So you never know what you're going to find. Okay. Number 15 is added. Emergency action plans and drills for local emergency responders and fire departments during construction and operation of the St. Croix Valley Solar Project are essential for public safety. Therefore, annual meetings to update employees, emergency responders, and firefighters shall be held in person or virtually and shall be coordinated by St. Croix County. Local officials from the towns of Richmond and Warren shall be invited to the meeting to assist with any other public concerns that may need to be addressed. We put this in as a finding. I know it's pretty close to an actual condition, but we elaborated just a little and put it in as a condition also. We felt there needed to be at least 1 finding related to public safety. Okay? So those are the only changes to the findings. Did the board have any other suggested changes from the draft yesterday that you saw and had more time to review to the findings?
Are you going to say something about the 80 acres in which they wanted the flexibility? If so, is there something that needs to be in the findings to support that?
We thought that there did not. The finding, it says in the very beginning that about the site has least multiple part. Number 2 is number 3. Number 3 says the site is approximately 981 acres with a facility footprint of approximately 680 acres and is located in the R1 and R2 residential districts. So with that approximately 680, it covers hopefully all the flexibility they need.
As I understand it, the reason for the flexibility is that they are concerned that as they begin construction and the placing of the piles and the panels, they will find landscape features that they do not currently know about that will make it impossible or impractical to use certain sites that have been drawn on the map currently. Is that your understanding also?
Somewhat. My understanding was simply that the exact layout of the panels may need to shift. They don't want to lose their total number of planned panels, and so therefore they may move them onto the portion of that 80 acres, or all. I don't know that they specifically said topography, but yeah, I took it to be many factors might impact that.
Go on.
Okay. If you want something added, certainly we can go back. Going down to the decision, changes that were made, on number 2, St. Croix Valley Solar Project will be monitored remotely, and we had and it was changed to and/or by an on-site operations and maintenance staff. And that was changed simply because it says on a 24-hour basis. And they explained yesterday that they will not have staff there 24 hours a day. Okay. On number 6, proposed site improvements was added. Well, actually, I believe it was edited quite a bit. Proposed site improvements must be constructed within the permitted area as defined and submitted within the conditional use permit application, submitted on. Final project design and layout, including panel installations, shall observe all required setbacks and shall be reviewed and approved by the zoning administrator as part of the land use permit. And because there we found another spacing problem. Period. The applicant. The applicant shall obtain a land use permit from the county to address stormwater management, grading, erosion and sediment control, and revegetation within the project site. So that does cover to some extent what we, or to the extent that we felt was appropriate. Okay. The next one is on the next page. It's kind of at the bottom. Number 8, the last bullet, the last 2 bullets, it was increased from 30 days to 90 days for recording with the Register of Deeds of the long-term stormwater management plan and the as-built plans, to allow a little more time for them to record it. Going down to the next page, page 4. Number 13, so 13, 14, 15, 17, and 18 and 19 were all added. A lot of these have to do with things that we had in the developer's agreement we moved out, and also things that were requested yesterday at the hearing. So 60 days prior to start of construction, they shall provide construction start date to the county. 30 days prior to the start of construction, representatives shall meet virtually or in person with county officials. 30 days prior to start of construction, they will hold an on-site meeting with local emergency responders, fire departments, etc. Emergency response information such as meeting points, local emergency equipment, construction plans. During construction, 1 or more emergency drills will be scheduled at which local emergency responders and fire departments will participate. As available, written copies of emergency action plans and site maps will be provided to local emergency responders and fire departments. 17, no later than 90 days after the commercial operation dates, that's when they will begin operating. St. Croix Valley Solar will schedule an on-site meeting inviting local emergency responders and fire departments to discuss on the operations site-specific emergency action plan, emergency response to grass and electrical fires, emergency response information such as meeting points and locations of emergency equipment and operation plans. No later than 1 year after the COD, an emergency response drill will be scheduled by St. Croix Valley Solar at which local emergency responders and fire departments will be invited to participate.
I note that you used the phrase, will be invited to participate in 17, but you didn't use it in 15 in the penultimate sentence.
Okay, you want that changed?
I know that, St. Croix County has the ability to have its emergency response department, or its emergency department appear, but we certainly have no ability to command other people to appear. All we can do is extend the invitation.
Okay.
Hopefully they will, be interested in doing that. I would not expect otherwise, but all you can really do is invite them.
So number 15, it should say will be invited to participate, correct?
Don't you think so?
Absolutely. And you made a good comment. We do have an countywide emergency response plan, a disaster plan. It probably would be a good idea to make sure that copies of all those items are forwarded onto that department, but that could be an internal activity. It doesn't really need to be in here. Okay. Any other thoughts on these so far? I'm not quite done. Okay. Number 18, after the initial meeting, St. Croix County Community Development staff shall coordinate an annual meeting in person or virtual with local emergency responders, fire departments, local officials from the towns of Richmond and Warren to review emergency action plans, plan site drills, update employees and emergency personnel, and assist with any other public concerns that may need to be addressed. Oh, I would note, I read it pretty fast, but in 17, we did specifically call out emergency response to grass and electrical fires. Hopefully that addresses the concerns needed. 19, we refer again to the developers agreement. Terms and conditions of the attached draft developers agreement between St. Croix Valley Solar LLC and St. Croix County shall be incorporated into the conditions of the conditional use permit. The finalized developers agreement between St. Croix Valley Solar LLC and St. Croix County shall be substantially in the same form as attached to hereto as Exhibit A. We did change the exhibiting numbering because this is one that would be attached to this document rather than as part of the hearing, and shall be recorded at the County Register of Deeds office by December 30th, 2021. Okay. With that, there's only one more change. Number 21, first sentence, following approval of the final project layout and design through the land use permit process, any minor change or addition. So this addresses the concern yesterday about whether or not the changes are minor, if they go into the extra 80 acres or not. And basically, from staff's point of view, when there's a major change, we believe it should come back to Board of Adjustment, generally speaking. But since this would have been thoroughly discussed by this board, it would be covered and we would feel comfortable allowing it to move into the 80 acres if you so choose to approve this.
Anybody want to speak before I do? My thought about that would have been to approve at the very outset the use of all of the suitable land in the 80 acres and just, have them modify their submission to show it as all subject to use for panels. And then if they chose not to do so, it would be no more significant than them choosing not to install panels anyplace else in their plan. The omission of panels would not be a change of significance that would concern the board, whereas the addition of panels, it has the potential to be. That was, the way I was initially going to resolve that. Do the rest of you have thoughts that you want to contribute? No?
No, I concur with your train of thought.
No, you're going in a kind of a different direction in which you're suggesting, I think, if I understood it right, that the word minor, the definition of minor is going to say that installation of panels anywhere in the 80 acres is a minor change.
Doesn't really say that, Buck.
No, it doesn't. You said it.
Correct.
You said,
That's how we
that
would-
would be your attitude towards it.
I would point out that we didn't actually, some of the wording that was referring to they shall follow the You know, they do, it goes back to number 6 that specifically says, proposed site improvements must be constructed within the permitted area, which is the whole entire site, as defined and submitted within the conditional use permit application and submitted on 9/7. So that document did leave out the 80 acres, okay? But there are a lot of important things in that document. So one of the other, that we really would like to keep that statement in there in number 6 in the decision portion. What staff's point of view was, and which we conveyed to the applicants in the meeting we had yesterday afternoon, was that our concern is not at all about having solar panels on the 80 acres. There are numerous water resources on that. Our job is to protect those water resources. They have been generous in many areas of the site, exceeding the minimum setbacks. We hope that they would continue that on the 80 acres. The land use permit is specifically, as described yesterday and during the hearing, is specifically to address stormwater management and the fact that parts of this are in shoreland. And so that is the appropriate place to determine how much setback there would be and what might be done to protect those resources. So we go back to, we still think it's appropriate, as long as the board is okay with it, to leave that decision, rather than say, as you're suggesting, go ahead and put it on all of it. Now we might be in conflict with a land use permit saying, don't put it here, and the board said, yeah, you can put it anywhere on the 80 acres you want, except for the setbacks.
Well, you have other language in other spots that protects the setbacks and the sensitive environmental areas, I think. Let me ask this question directed to finding number 3, that's on the first page. It says the site is approximately 981 acres, and the facility footprint is approximately 680 acres. Is the 80 acres in question here in the southwest quadrant, is that included in the 680? It certainly is included in the 981.
Yes.
Yeah. Well, I don't know, Joe and I may be the only ones who think this is an acceptable way to deal with it, but for instance, in the decision paragraph number 6 that we've just been talking about, suppose we were to say, we were to just add the number 981 so that it's clear what permitted area we're talking about. That, in other words, all of it.
Okay.
So it could read, for example, and I only speak for myself at the moment, so we'll have to get some, at least body language from other members of the board here, but it might read, proposed site improvements must be constructed within the permitted 981 acre area. And then go on, you know, so the only addition would be the 981 and changing it to acres.
And that could be the full entirety of the site. I note that in number 3, we said of approximately 981 acres. So I would suggest using the same wording.
Yeah, I don't know. Is that the sort of solution that works for you, Joe? Yeah? Yeah. Do the rest of you see a flaw in going at it that way? Is that too lenient, or?
No, I don't think so, because like you said, I don't believe it's too lenient, because as you said, there are other parts in the decision and the, you know, in the agreement that talks about, you know, they still have to abide by the setbacks, and so, you know, when it comes to wetlands, I mean, they're going to have to, so.
So maybe that's a good way to do it, and I like that better in terms of, you know, we're setting a precedent for our county here with this whole decision, and I really am leery of setting a precedent that the word minor includes a whole 80 acres.
That was exactly the staff's position, is that we would not see moving into that large of an area. We actually discussed that specifically, and we said 80 acres is too much. We can't say that's minor.
So, yeah, so why don't we do it that way tentatively, and before, before too long here, we'll be taking a motion, and we'll see if somebody thinks we've gone a bridge too far here or something.
Okay.
All right.
Do you want an additional change then down in the, so I've changed it in number 6, within the permitted area of approximately 981 acres, as defined and submitted. And then down here in
Does that impact some other spot?
following, number 21, which is what stimulated this conversation. I don't know if that makes any difference, but following approval of the final project layout and design through the land use permit process, any minor change or addition? Or should we strike that?
I think then we're okay, because
Okay.
I mean, minor means small. It seems to me we're okay with that.
Okay.
Yeah, all right.
All
Proceed.
right. Any other changes to the findings of fact and decision? And we can come back to this after we go over the developer's agreement, but I'm going to hit save at this point. All right. So if you'll move to your other document, the developer's agreement. Knowing you have not seen this before, would you like us to give you a few minutes to read it through?
Please. Till 11 o'clock?
They're going to take 3 minutes to read it through, so we're going to have complete silence.
It occurred to me last night that there's one really serious weakness in the concept of applying salvage value, and that problem is that the county cannot sell property it does not own. In order to realize the salvage value, it would be necessary to be able to convey title, to do a bill of sale with warranty of title to the steel and the panels and the wiring and all the rest of the stuff. Where, and I don't find it in here, where does it indicate that the county would own such when the applicant or its parent or its assignee under the assignment provisions here would take over the project? How would the county realize the salvage value if the applicant or its parent or an assignee declared bankruptcy and the bankruptcy court and the creditors it represented asserted that they owned the panels and the metal and all that kind of stuff? Did you address that, Mr. Cox? Do you have an answer?
Well, you're right, the agreement doesn't address that.
So how do we get to it? Is there something in the letter of credit where the bank that's issuing it indicates that it owns that property, that personal property, some of which might be so attached to the land that it raises that messy question of what is a fixture, you know? and that passes automatically to the county when we make a claim on the letter of credit? I mean, in a business like theirs, I would expect them to borrow against the value of that, of those panels and that steel. And that lender would want the first security interest. They would want to be in first position. They wouldn't want the county to be in first position. That strikes me as a significant problem that I didn't think of yesterday. Maybe the other counties that allowed salvage value found a way to address that, or maybe they just didn't notice it. Sorry, members, I guess I may have been talking legalese, and it may not be obvious what I'm talking about and why it matters.
No, I think that's an excellent point, Mr. Chairman, and I had the same question in regards to the landowners, and in the case of default, what responsibility would fall back on the landowner with fixtures installed on their property, and what would, say, come to the county or other creditors or whoever. So I think I echo that. My only further question was, is there any verbiage in the rental agreements with the landowners as well?
Yeah, presumably their
For their protection.
lease payments would stop if the
Yeah,
business
for the
stopped.
landowner's protection, and/or that would conflict with the county's ability to help get the salvage value.
Yeah, they might want to grab onto any value they can in order to realize their missing lease payments and restoration payment, restoration of their land so they can go back to farming it or whatever. I don't know. Do we have answers for that? Do you want to confer with the applicant and see if they have answers to that?
I would suggest that legal counsel confer at this point. We have reviewed numerous documents from other counties, and it hasn't come up. We did talk about what would the situation be if and when the county would be involved. We talked about the concept of property owners not working together or not agreeing on how to move forward for salvaging, and then deciding that they would perhaps not pay their taxes, go to tax deed, that kind of thing. We are concerned about it being an environmental hazard in the meantime, as things deteriorate or scavenged or something would happen. That's our point of view. Those things came up which are related to what you said. We did expect that the land is already owned by someone. It will continue to be owned by someone. In theory, that person would be the first to move forward to salvage. And in such case, we would never activate our letter of credit or do anything. It's as it might become it's like, for our minds, it was like, if it moves into its in violation, at that point, what would we do? And we go back to also, if at some point it's totally on our shoulders to figure this out, we're not in the business of salvaging, as was mentioned at the hearing yesterday. We would basically be ending up going through the process of hiring someone else to take care of it. So, and dealing with whether or not we had enough money to do that. This is a very long time into the future, as was said yesterday, 40 years or more. When there becomes, they could end up with very little salvage value at some point, and then at that point, there might not be an interest by the landowners in getting it cleaned up. They might be looking for help. There's all kinds of situations that could occur. But I would suggest legal counsel is in the best position to discuss this.
Can we take a break?
Pardon?
So, can we take a break and talk to the applicant about this?
Sure. Why don't we see what else we might have in comments on this document? Does anybody else have? Yes, Steve.
Yeah, just on the topic of the decommissioning costs and the salvage values, my experience is that when there's an appraisal type value being put on something, there can be judgment calls and different opinions. So in the verbiage here, it mostly sounds that the applicant can decide what those values are. And I wondered if there should be an opportunity for the county to disagree or to perhaps obtain their own values if they disagree with the ones being proposed. Although that may be at our own expense.
Yeah, I read that commission and update to mean that essentially St. Croix Valley Solar would front the money, but that the actual update of the decommissioning plan would be done by an expert of the county's choice. But it doesn't exactly say that here, and I think we would need to clarify that and make sure that's the understanding of the applicant, too.
Yeah, perhaps a
Maybe
third party
like-
wants to be hired, but I felt like maybe a little more description about
Yeah.
who and how those values are calculated. Hopefully doesn't need to be used, but maybe it maybe is helpful if it happened.
Sure.
There is at the, and then we can certainly add, this is probably the appropriate location to add it, but there is at the end a process for disputes. On
Yes,
page
there is.
5, number 8. And so if we disputed the salvage value or disputed some of that, there's a process, including at some point going to mediation, in which we could try to resolve any disagreement.
Yeah, obviously, we hope not to have to use that.
Absolutely.
We hope to have language that is clear enough that there's no need to be mediating.
And I don't know that we know of experts at this point. It might be a mutually agreed upon expert, because I don't know what
Yeah.
companies there are, and I don't know who would.
Well,
We do our best, but,
my research on the internet that there are reclamation or decommissioning companies who do this. So I'm sure there's experts out there that do this.
That do studies of the value of.
Yes.
The cost of decommissioning.
Yes.
Yeah. Okay, so there's a point, and you probably want to discuss that also with the applicant offline. Anything else, members? I've got just a couple of little nits. On page 3 of it, letter D at the top, so that'd be 3D. It takes the, it says from year 6 through year 9 of project operation, and I think that's the only time I noticed that phrase of project operation, and I think it's a little, therefore it's ambiguous. We probably mean years 6 through 9 after the COD,
yep.
don't we? And it'd probably be better to say that. Because, well, for example, if for some reason or other they stopped operating for 3 months, would that, shift the date by 3 months, or would it not?
I'll use the same language as in the one right below it.
Okay.
Year 10 from the project COD.
I assume that's a non-controversial change. Then the insurance provision on page 6, it's paragraph number 10. It talks about providing evidence of an insurance, but normally what we do with that, I mean, it doesn't have to be this way, but normally we would have the county named as an additional insured. So there'd be a certificate of insurance that not only shows there is insurance protecting St. Croix Valley Solar against claims, but also claims against the county on account of the activities of St. Croix Valley Solar. So you can think about whether that's important here or not. Okay, it sounds like it would be time to take a kind of a recess unless, Joe, you said as we were coming into the building that you had some question or other that you wanted to ask the staff. Should we get that out on the table here?
Well, we can real quick. We discussed yesterday briefly the emergency notification stuff, but we never actually came to a conclusion as to how that would be advertised. And I'm just wondering if we're going to put some sort of placards on the fences or signs on the doors or, so if somebody walks up and sees an issue, they've got a phone number they can contact.
Oh. A phone number for St. Croix Solar?
Yeah, an emergency response phone number. Traditionally around substations and that sort of thing, the owner puts up some sort of plaque that says, in case of emergency, notify this phone number. And I just wonder if we're going to do the same type of thing on these around the fences here.
Yeah, okay. The point noted, I'm sure the applicant heard you speak and they'll deal with it as they see fit. All right, well, I see it's 11:18. How long do you want, Mr. Cox?
However long it takes.
So we should get back together at 12:18? Oh, geez, no, is my thought too. 10 minutes?
10 minutes.
So 11:30 then. All right. Do you need an introduction to Attorney Ryan Carey,
No.
Attorney Scott Cox? Okay, you guys already know each other. Good. Okay, have at it.
I would also note that there is a type, that the numbering should have gone E, F, G, H, so I'll correct that.
All right. Good. We'll see everybody at 11:30. Mr. Cox, are we waiting, do we need Ellen Denzer?
Yes.
Okay.
And can I ask the board that a representative of the applicant be heard on?
This is not going to be evidence, right? You're not asking to reopen the hearing.
No, but just on their,
I mean, you could speak for them, and that would satisfy, I suppose, the letter of the law. You
but
want
what's the
to-
concern about? They're not providing evidence, they're just providing argument or
Discussion,
discussion.
negotiation, attempting to sway the board's decision,
Yeah, why not?
and you'd rather they be allowed to speak for themselves rather than put you in the position of advocating for them.
At least as to one of the concerns. Well, let's see if, what,
I could certainly go there. I mean, I'm only concerned about getting it right, and if our decision is challenged in court, you'd have to defend the process. If the process is challenged, you'd have to defend it. If you think that that's not creating a problem, then I'm really comfortable, and I'm sure my colleagues would be also. So why don't you introduce the person that you would like to address the board?
okay. I guess I would request that Attorney Ryan Carey be heard on the issue of decommissioning and salvage value and the position of parties relative to the removal in the case of, let's say, bankruptcy or some other dissolution of the applicant's company,
Or the owner of the equipment?
the owner of the equipment, right?
Yeah. All right, Mr. Carey.
Thank you, Mr. Chairman. So, Chairman Malik, you asked a question about how the county essentially enforces the decommissioning process through the security offered. And I thought it'd be worthwhile to walk through how we would see the possible options that could occur in the decommissioning process. And so, first step, when in the event of the termination of the project, when the project is no longer viable, Avangrid, per each lease entered into, is obligated to decommission the facility, to remove the property from the land. There certainly could be a situation that could arise where the applicant defaults and doesn't do that. In that case, I think there are two parties that would intervene prior to the county. First could potentially be a lender, if there is one. A lender could step in and say, well, we have a lien on that equipment. It has a significant salvage value, and therefore they would have ample incentive to remove the property, the personal property, the equipment from landowner's property, sell it, and apply it against loan proceeds. Now, second, and maybe not necessarily in that order, but certainly then the landowner would also have a significant interest in having that property removed from their land. And in some cases, those landowners have letters of credit pledged to ensure that they will have the resources to remove the property from their land. And so as between, I think, those first two parties, there's more than ample incentive to have that equipment removed. Now, I think the question is, well, what if the creditor says, hey, that salvage value isn't worth my time, I'm going to leave it. And landowner says, for whatever reason, I'm not going to engage in that at this time. Then I think the county, as the last resort, could initiate enforcement mechanisms to have that equipment removed, and then at that time would have, because the salvage value has decreased so much, would have a letter of credit to pull from and have money available to either contribute to a landowner who does not have that resource, or to they themselves, if it's gotten to the point where there's been a tax deed forfeiture and the county now owns the property, they would have the money to remove the equipment from the property. And so I think along the way there are several steps that would have to occur, or several failures that would have to occur before the county would even need to get involved.
What do you think of that, Mr. Cox?
Well, I think that's accurate. I think the county is the facilitator of last resort here, and it's got, pursuant to the agreement, it's got a pot of money based upon estimate, and we've got some agreement about the language about how that gets determined. We've got a pot of money based upon the decommissioning costs and the salvage value that provides enough money for the county to decommission as a last party here. So several things will have to fail before we even get there. And
Yeah, what's the bottom number of the letter of credit how much is the minimum that the letter of credit could ever fall to? Would it be zero after year 6? Or does it stay at 2 million?
it stays at 2 million until year 10.
And then it could drop to nothing, couldn't it?
Not the way it reads, no. It could not drop to nothing. What would happen is, it's a combination of the decommissioning cost and the salvage value. If the salvage value is zero, there is still a decommissioning cost that would be estimated at the latest in year 30, and then that amount would at least be there.
But if you posit that the possibility that the Solar Valley or whoever then is owning, operating, doing this thing, is bankrupt, how do they pay the premium for any letter of credit after the 2 million expires at the beginning of year 10? Mr. Carey.
If I could just try to answer that. So each time a letter of credit is issued, typically, and I'm not going to say exactly how this will go, but typically when a letter of credit is issued prior to that particular letter of credit expiring, the beneficiary of that letter of credit will get notice. And prior to that termination or that expiration of that letter of credit, if a replacement letter of credit has not been secured and provided to, for example, in this case, the county, your mechanism under that letter of credit will be to draw the entire amount on that letter of credit that's about to expire. That's how you protect yourself.
So we need to make notes in the file for those very important dates, Ms. Denzer, to exercise that right if we're going to do it.
I would explain a little further that we already do that in the case of major subdivisions. We've already been through this. We have staff who've been through it back in 2007 during the recession.
Good.
We had letters of credit that we literally had staff hop in a car and drive over to the Twin Cities to cash the letter of credit as it was expiring within hours. We have notifications. However, as I've said, this is a lot of turnover in staff. There is human error, but we have a whole tracking system that we have set up. We have multiple staff who monitor that, and we are notified. And that's also part of why we requested specifically, and it's in here, an irrevocable letter of credit, so it cannot be revoked without notice to us. So we have a system. It can always be improved, and we will work on that and discuss it with our financial director, but we have been through this, and we have done it.
And we also have it on non-metallic
Mining,
reclamation.
yes. We already do that.
Right. And this is the first time we're allowing salvage value to enter into the determination of the amount of a letter of credit, but
Correct.
I take your point. Okay, I'm satisfied. Do the other board members understand that enough, or rely on my judgment? Whatever. Whatever you want to do. Okay, thanks for delving into that and working it out. It does occur to me one other thing, and maybe this makes no difference to you at all, but another source of letters of credit besides banks are insurance companies. You don't, in this document, you haven't made it possible for them to use an insurance company. You've only suggested commercial banking organizations. If you want to give them that flexibility, you certainly could, as far as I care.
That was language suggested by the applicant.
Okay, well, I guess they're happy with their language. Any other issues that we have here?
So with regard to the decommissioning, on the bottom of, I can read through my writing, page 3, we've agreed to a change, and I don't know, Ellen, if you want to type or,
I will type as soon as I get to the right spot. Decommissioning plan. There's 2 changes, so I'll start typing here
okay.
as you talk.
So after letter D on page 3, the first sentence reads, to establish the estimated decommissioning cost and salvage values at each 10-year interval, St. Croix Valley Solar shall commission an update to the decommissioning plan to be performed by a mutually agreed upon third-party expert, period.
All right.
And then there'll be another change in that paragraph too.
Did you want that to be a continuation of the sentence? Or
Yes,
that's what I thought.
continuation of sentence, strike the
period.
period, comma, instead of, to be performed by a mutually agreed upon third-party expert, period.
Yep.
And then a sentence at the end of, after this sentence, the updated plan shall be provided to St. Croix County 6 months prior to the 10, 20, and 30-year anniversaries of the COD.
Oh,
I'm just
after that.
reading.
I'm sorry. You're right. Keep reading. I'm sorry.
Next sentence, St. Croix County shall approve the updated salvage value and decommissioning cost, comma, said approval shall not be unreasonably withheld. And so if there's a dispute about that, then we go to the dispute language in the agreement.
Exactly. That sounds good. Yeah, it's agreed. Did you want to do anything with the additional insured on the certificate of
Yes.
insurance or not?
So they've agreed to an additional sentence on paragraph number 10 on page 6, that St. Croix County shall be named as an additional insured.
Correct?
Yes. Yes.
Anything else, Mr. Cox?
No.
Anything else, Ms. Denzer?
Only thing I would ask is if you have had enough time to read through all of the development agreement, and if you had any other questions or changes or things I can go over. It will have a cover page. It will have a recording to be recorded against, to be recorded, and it will have a, I always forget the term.
Addendum?
Yes, and it will have, and, excuse me, Mike has the two addendums that are referenced in the beginning of the document on in numbered recitals, number 2, that he can just show you or pass around quickly.
Yeah, they're basically a map of the
Overall.
property and then the legal descriptions of all the affected parcels of the application to provide notice to any third party about the developer's agreement.
I don't have any need to see that.
Okay.
Steve?
One further question, just to confirm with the board here, as well as staff, while we're beating up the decommissioning plan. Is 10 years a appropriate time length? I'm not that familiar with solar panel technology, but I do know that in 10 years, my cell phone will be a paperweight. So I just want to confirm that that's an experience of our staff, and the opinion of the board is that 10 years is appropriate.
I think Mike can answer that. He's had more experience, and he would be the appropriate person to reply.
Well, the way I would respond is, I mean, I've been involved prior to coming to work for St. Croix County on the permitting side of a dozen smaller projects. I mean, these projects, and certainly the applicant, the developer could respond to this as well, but these projects are built they have a lifespan, and to make the economics of the project work, they have to produce electricity for that extended period of time. And, you know, this hasn't been viewed as a big concern that somehow after 10 years the project's going to be disassembled or completely refitted because of the level of investment that's occurring in these projects, for one. You know, I might compare it to the technology for power plants hasn't changed or has changed, but you still have power plants that are in operation that have been recommissioned and extended. I have personal experience with the nuclear, Prairie Island nuclear plant in near Red Wing, as an example, where the importance of that power generation and the ability to for it to keep producing the power over an extended period of time is what makes the economics work for these power facilities. So that's my take on it, my view. These facilities are going in all over the country, and I don't think because the panel technology changes that it's necessarily going to mean that the existing facilities are phased out well before their designed lifespan. And we did research this a bit in the past. I have personally, when I was educating myself on the industry, and that's the conclusion I reached. But I'll leave it at that. There may be other views.
No, thank you. That satisfies my question.
Ms. Denzer, is it your view that this permit, if granted using the language we've got now, would allow the applicant or its successor to replace the panels with more efficient panels without coming back?
Yes.
How about the elements within the substation? If there are more efficient pieces and components, could they replace those without coming back for a new permit?
Yes. Mike, would you confer?
Yeah,
concur?
and you know, we are talking about another process, albeit a much more limited one for the substation, and you know, we could make that clear in whatever action you take on that.
No, I think just to, Mr. Shallow's point, we all expect technology to change in the direction of greater efficiency, and the ability of this solar installation to produce more megawatts with more efficient equipment sitting on the same footprint is presumably highly desirable. And we wouldn't want to stand in the way of it.
The conditional use permit runs with the land. Change of ownership will not affect that. It can be improved and slightly expanded, just like any other conditional use permit when someone improves their business.
Well, members, we could possibly be at the position for a motion here.
Well, I got one more question.
Go ahead, Joe.
Ellen, our town developers agreements, prior to construction, we plan a meeting with all the subs involved. Is that something that is in the planning or been discussed, or what's your thought on that?
That is in the decision. We added that in. Perhaps you didn't note, when I said there was a long list of them added. Number 14, at least 30 days prior to start of construction, representatives of St. Croix Valley Solar shall meet virtually or in person with the county officials responsible for administration of the project's conditional use permit and land use permit.
Okay, will that include the subs too then, or just the primaries?
Usually they bring their subs, they want to bring their subs, and that usually gets detailed out during that meeting, and usually they also schedule follow-up ones as appropriate.
Okay, thanks.
So who wants the honor, or are there more comments or objections?
I would just make one parting comment, I guess. If nothing else, 'cause it'll make me feel better. As a farmer in the area, it still pulls the strings of my heart a bit to lose farmland. And I do want to recognize that with the loss of that land, there is local economic activity lost. It was mentioned by staff that these are going up all over the state and country. There's seed that won't be sold. There's parts at the implement dealer that won't be sold. There is a impact to the local community. I think this is still a net gain, but as we move forward, I think there is a little consideration that could be recognized and how it's going to change our rural community. Thank you.
Duly noted. Yep, that's part of what the state legislature took back to themselves, and so that we're very limited in the scope of what we can do. It has to do with health and safety and other changes that don't change the economics of the proposal, essentially. So, yeah, times are changing, aren't they? Anything else? Okay, who wants the honor of making the motion? Motion to approve?
I'll make that motion to approve the conditional use permit, including the addendums, exhibits, and the joint developers agreement that's as presented.
I'll second it.
Second from Joe. Any further discussion? All in favor, vote aye.
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 Any opposed, vote nay. It's unanimously approved. Thank you all, staff, applicant, everybody. We've all learned a lot, I think. It's all good. And I believe we have no further business. Do we need, we need some scheduling discussion, don't we,
Yes.
about that January meeting? Let's see, Julie indicated that this room is available on Monday, the 10th, I think it was it, of January, and Scott indicated to me that he could be available that day. That'll be a closed session, and I think we only do that one item of business unless we have some housekeeping type stuff.
The likelihood is I'd be unavailable for that.
You would be unavailable. Now,
Basically, I got surgery 5 days before.
so we'd have to meet prior to January 5th, or more than, say, a month after your surgery.
Well, I think-
3 weeks after your surgery,
2 or 3 weeks, I think I might be okay. 2 would be
yeah.
touchy, 3 would probably be better.
Now, you were involved in the
Yes.
decision on the
Yes.
matter that we're dealing with here, but that doesn't make you essential in whatever business we're doing with Mr. Cox that day, but it does make you desirable.
Yeah, because I think we're taking a certain approach in the case, and could be a resolution if,
Is there anything available before January?
could be a resolution depending upon interpreting the board's decision and what the board intended, but
Ah,
Could I point out that since it would be a closed session, is my understanding,
yes, it would be.
it does not need to meet in this room.
Oh,
It can meet in 1216. So we should look for a different room.
could meet in Mr. Cox's conference room.
Yes, it could. It could be in any one of the other conference rooms
Could be
because we
cozy
do
in
not
there.
need to have the public present at all.
That's right.
That would be my understanding is that's the only agenda item we would have.
That would force that.
Yes.
Yeah.
Could I attend virtually to that, if I could? Or is that not a good idea, and I might even be under medication at that time, so.
Well,
I don't know.
suppose we have it before your
Right.
surgery, so
Right.
sometime between between now and January 4th. And how soon are you available for this, Mr. Cox?
oh, I could talk about it right now if it was agended, but
Oh, you have all the information you need already.
basically, yes. I mean, I probably want to review the transcripts, but I would say anytime after maybe next week at this time would be,
Okay,
give me a little time to
sure.
look at the transcript, but
Well, whatever prep you think you need. So we're basically looking at something from the week of December 13th up to no later than January 4th. And who else do we want? Mr. Peterson, was he involved in this one? No, I don't.
Scott,
Yes.
my
Was Mr.
question to
Nickum
you
there?
is,
Yes.
how far in advance do we have to
You were there,
notice
but
the
no.
meeting, even though it's closed session?
24 hours,
Thank you.
almost simultaneously.
Yeah. And this, yeah. I mean, it doesn't have to fit with the print schedule of the media. It just they just have to be notified at least 24 hours ahead of time.
Yeah.
So, publication dates and newspapers aren't involved in a thing like this. How about Monday, the 13th, in Scott's conference room? So
Whatever, yeah.
they're all,
Monday, December
they're
13th.
all available?
And I think Ellen should be there and
And
Mike
Mr.
was at
Mike.
the- Yeah,
Sure.
too.
presumably. You guys available on the 13th? What,
Yes,
okay, and?
I am. Mike, can you check your calendar?
What we know about Dave Peterson doesn't help us, I guess. We don't know that he's planning to be gone, do we? I confess I don't think I know that he's got any travel plans at all.
Yeah, I don't know of any. We would simply have to have Julie contact him soon. And Mr. Nickum was not feeling well enough to attend yesterday and today, but maybe by next week he would be.
There's a point too, yeah. Let's see, the four that we really want are Nickum, Peterson, Miller.
Miller and Spaniel.
Yeah, so those four. So you two are for sure. The other two are, so why don't we pick a tentative date that's subject to Julie confirming with Dave and Dave? Huh?
Okay, so the 13th is free. It's free for
10
you?
o'clock or?
free for me, make it free.
Okay, and How much time do you think you need, Scott?
I can't imagine it going over an hour
So let's plan for an hour.
without
and
a
half.
song and a dance act, but, you know.
10?
We charge extra for your inflicting your humor on us.
Let's suggest 10 a.m., but also, is there any time that day, if the other two have a conflict, that you guys could not attend? Why, you're all three wide open that day?
Yeah, I'm not an essential person either.
No, but it would be good to have
I'd
your,
like to be, but I'm not essential.
you have a great deal of knowledge, it would be helpful to have you there, just generally speaking. Okay.
Okay, so Julie will confer and she'll email us.
Would you like to look at an alternative date right now? So
Sure.
in case they say they can't do the 13th, well then, how about the 15th?
Excellent point.
That's a Saturday? Oh, no, I'm looking at January. Excuse me, you're right. I'm sorry.
December.
I'm looking at the wrong day.
I have a bunch of stuff that day, but again, I'm not a critical person. Food shelf all morning.
I can do the 15th, but what about Tuesday, the 14th?
I can't do the morning at all.
Okay,
Go to the crib.
Oh, fish cribs? Mm-hmm, yeah.
and afternoon, it might run into afternoon too?
Depends on how many helpers I get. Can encourage Dennis Merkel to help me, we'd be done by noon for sure.
Well, he's planning on having at least one person there, so.
I could do the afternoon of the 15th.
I could do the
Okay.
afternoon after 1.
Yeah,
So-
after 1:30.
Morning of the 13th, afternoon of the 15th.
There are two choices.
Okay. Julie, if you could reserve those on Mike's and my calendar.
And I will wait to hear from you.
I think that works very well.
So this case is unlikely to be appealed, the one we dealt with here today. So
I think we've been
here are
pretty
my
generous on
papers
just
for,
everything.
recycling.
Yeah. But it was good to set a precedent with this. We do have interest from 3 other solar companies.
Yeah. I might have said, Mr. Shala, that I consider it equally, not to take a thing away, not to diminish your point at all, but I consider it also somewhat sad when we have housing developments built on good farming land. As we sometimes say, the last crop is a bunch of houses.
It's tough when it gets planted to houses, so I appreciate that
Yeah.
sentiment. And
Yeah.
times are changing, and hopefully for the better.
Yeah, hopefully.
All right.
I think the county ought to enact an ordinance that says only farmers can build 1-acre lots on their own property, no developments.
Hey, you may encounter some opposition.
You get a lot of opposition on.
Every banker in the area. If you want to press the print button on that decision, I can sign it.
I have to go move it from this special meeting folder into mine, because we've
Ah.
never set up the printer, which all we have to do, please think about doing that in the future, Julie, is to set it up so we can print from there. So it'll take me an extra 3 minutes. I can't do it yet.
Well, I can hang around for 3 minutes.
Hey, Mike, who does the electrical inspections on a project